When it comes to YouTube or game development, there's a lot of talk about copyright. People arguing back and forth endlessly about what you can and can't do legally. But I suspect that a lot of what people talk about when it comes to copyright is just myths, passed down across many forums and comment sections. Those guessing that this episode isn't going to be particularly fun, you'd be right. Copyright, that is. Huh? No? No? Well, okay. Now, before I start, let me just set out some ground rules. First, I'm going to use copyright as a general term. I don't want to get into arguments about what is copyright, what is trademark, or a patent. Second, I welcome your thoughts, as usual, but a lot of what I'm talking about is a tangled mess of contradictory laws that vary from country to country. I mention this because the gist of this video is going to be that copyright law, as us laymen understand it, doesn't really hold up. So unless you're an expert on national and international copyright law, citing your version of the copyright myth or pointing to passage A5 of the Federal Penal Code of Wyoming isn't going to be very convincing. Let's start with a simple example. At some point I heard that Sega owns the copyright to floating arrows in games, and apparently The Simpsons Road Rage was sued over this. But I find it hard to believe that Sega owns the right to floating arrows when so many games use them. Not only that, but a quick Google search about the lawsuit makes it seem like Sega filed the lawsuit because Road Rage was a clone of Crazy Taxi, and the case was settled out of court. So this idea that The Simpsons Road Rage had a floating arrow and thus was sued by Sega over it, and a judge came down in Sega's favour, doesn't have any basis in reality, especially when The Simpsons Road Rage had a floating hand pointing the way, not a floating arrow. This fact also torpedoes the other common defence, that other games with floating arrows made some minor change to the colour or shape of the arrow to avoid being sued. Not only was The Simpsons a floating hand, but if changing the colour to a different shade of green or making the arrow a slightly different shape is enough to not get sued, then what good is the copyright then? Sega wouldn't own floating arrows, instead they would own a very specific floating arrow. It's like the difference between owning the rights to Superman and owning the rights to all superheroes, which brings me neatly to another point. You can't copyright generic things, so you can't own the rights to stairs or the word the. But when it comes to games, some people claim that companies can copyright specific game mechanics. But I don't think that's the case, because if they could copyright game mechanics, even generic concepts like floating arrows, why wouldn't Activision copyright aiming down sights and completely kill off all of the Call of Duty clones? If someone else owns those rights already, why haven't they sued Activision and made a ton of money? Another issue is one of enforcement. To put it simply, companies can claim to own whatever they like, but without the police to enforce their claims, they mean nothing. It's kind of like the way various people claim to own the moon. There's no legal recognition of their ownership, and they either can't or don't enforce the claim. As such, the claim is meaningless. Enter DMCA, which stands for the Digital Millennium Copyright Act, a tool supposedly made to protect copyright. In practice, it seems to be mostly used by companies to silence criticism and to take the money from popular videos. After all, why does it seem like popular YouTube reviewers and pundits that get DMCA'd the most, and why does it seem to be large old-fashioned companies and controversial figures who issue strikes the most? Well, I don't know. Could be coincidence or confirmation bias, but most likely these are people and corporations that don't want to be criticised, and thus will abuse tools intended to protect copyright as a means of silencing criticism. To me, the fact we've yet to see a YouTuber go to court over this suggests that this is all about shutting people up and making a bit of money on the side than any kind of actual legal challenge. Finally, there's the laws about specific products like guns and cars appearing in games. A film can mention them just fine. In some cases, car companies will even pay filmmakers to feature a specific car. But in games, apparently you have to get permission from the company and sometimes even pay money to have, say, a Ferrari in your game. Who made that rule up? It's stupid. Many games get around this by changing the name so that you can have a Ferrari, but now it's called a Mirari or something like that, and that's okay. I know it's a Ferrari, you know it's a Ferrari, everybody knows it's a Ferrari, just call it a Ferrari. Now, I understand if you're talking about the title. If you call your game Ferrari Challenge or something, then I guess it makes sense as it implies some form of authenticity. But simply mentioning Ferrari in the game? That seems stupid to me. And again, despite people claiming those are the rules, there seems to be no consequences for breaking them. I've seen cheapo games that have real gun names, and I've seen big games where they don't. How come some games slapped together by 5 guys in Russia over a couple of months can get permission to use real gun names, but a big budget AAA game can't? And once again, if they didn't get permission, why didn't they end up in court? The guy who tried to copyright the word edge tried to take people to court, and I've heard of many fan games and mods being shut down by game companies, but I don't recall ever hearing of someone being sued because a game mentioned Kalashnikov without permission. I could go on, but I'm sure you get the point. The various rules and laws for copyright are often stupid and inconsistent, and seem to be passed from person to person with little to no evidence of them being true. And if these rules are true, they don't seem to be enforced with any kind of consistency, if they're even enforced at all. As a result, I think a lot of these copyright rules are myths based largely on rumours, assumptions, and the occasional bold claim. Thanks for watching. Bye!